see this as political, administrative, but also legal. So the politics is that we don't know the composition of the parliament yet. What is not clear is how many seats are in contention, because initially EC said there were 9, and then the matter that was sent to the High Court had 6.
Yes.
And now what will be determined tomorrow is 4. So it's very confusing. Do you have, from off the top of your head, the 9 constituencies in question?
Yes, so initially the Ahafano enclave.
North and Southwest.
Yes, that enclave. Ebijama, that enclave. Then you have Obuasi East.
Okay.
You have Domekwa Benya. You have PAA KWESI Central, Ablekuma North, Tema Central. Those,
and then Techiman South.
And then Techiman South. So those were the problematic constituencies. But we had always contended that those seats were declared, I think 5 of them were declared in our favor. There were some that were waiting to be declared. And for that matter, our position, and that is why if you watch the Supreme Court proceeding, I drew the attention of the court to the fact that there was already a judicial review application in the nature of certiorari, because when the various presiding officers had declared those 5 constituencies, the Electoral Commission did a press briefing one Friday evening claiming that they have invalidated those results. So the next Monday, which was the 16th of December, I filed at the registry of the High Court, the judicial review, that one, the presiding officers and the returning officers make their declaration in respect of those 5. They had become what you say frontus officio. And so if anybody is dissatisfied with it, the person must go to the High Court, pursuant to Article 99, to actually challenge the validity of those declarations. And that was not done. So it was in between. So the next day, which was the 17th, then the 6th MPP parliamentary candidate caused to be issued at the High Court the various Mandamus application, which brought about the 20th December hearing, and which subsequently resulted in the intervention from the Supreme Court. So basically that's where we are.
So let me just understand from your own what happened, and I'll speak to Atta, who is also on.
Very well.
So when the 6 went to plead this Mandamus, which was to ask the High Court to direct the EC to recollate or collate, you said that you were supposed to have been at least given a chance to join, because you were also an interested party. The High Court judge disagreed with you. Then you went to the Supreme Court to file what you call a certiorari, to set aside what the High Court had done.
Correct.
Now, from what Justice Pwaman read, did they agree with you entirely? Because it seemed as if you got some of the relief you wanted, and some of them you did not.
So in terms of the substantive application, has what we call grounds. Ground A, B, up to E. Even for me, ground A alone succeeding was enough. However, there were other grounds that we thought we could formulate. But notwithstanding the fact that the court says not enough evidence was provided, it still went ahead to say that the matter be taken away from the judge. That for us is all that we wanted. That at this point, his mind was made up relative to the issues. And so it cannot go back to him. And thankfully, the court agreed with us on that score. But the bigger conversation for us was the issue of hearing. And like I pointed out before the justices of the Apex Court, you see, if you look at what happened in the High Court, Bernard, you have a situation where you say, you call, say, Anodompre, or you call Akyea Free, and then she's up. Then the lawyers announce themselves. Then the judge asks EC lawyer, are you opposed to the application for Mandamus? Then the EC lawyer says, I am not opposed. That for me put me on the like on alert that no, it appears.
So if the EC had said they were opposed to this, you would have felt that at least there were two sides intentions.
Yes, because you see, the issue with Mandamus is that when there is dispute as to whether there is a legal duty to be performed, it's enough to refuse it.
What if the EC felt that it was very clear that they hadn't performed their function, and therefore if a party felt that the original,
then there was no need for the Mandamus.
Which means the EC would have had to just correct.
So there was no need for the Mandamus. And you see, for me, I saw it as a ruse, a charade. And that, you see, first of all, the Electoral Commission called this affected constituent and said they should come to Tesano. So at that time, the EC had made up its mind to do the recollation or collation. And so the issue that they needed a court order in order to perform that responsibility for us was a ruse. And so immediately my attention was drawn to the fact that the Electoral Commission or the various applicants had put this Mandamus application. Immediately I wrote a letter to the registry of the court that I want copies. I personally sent a letter. And once I got the copies, I said, no, this one, it requires me to intervene quickly. And
you were given a chance to speak verbally.
Yes.
But you were not allowed to file or put in any formal process.
So you see, usually this is how our processes run. If maybe for whatever is worth, a person may file a process. But once it comes to attention that your interests would be affected, there's something we call joinder. Which allows you to apply to join the process. Okay. And so immediately our attention came, we applied to the court that we will not sit down for a decision to be making before we will now try to. So you add us so that you can hear our side before you make any decision. That with respect,
was not
the trial judge didn't agree.
Akyea is MP for Akyea South, Guapa South, forgive me. And he's joining us to also express some views on where we are so far with this interesting situation. Tomorrow, 31st, will be the determination of the original Mandamus application, with now NDC and some of their parliamentary candidates being represented there. Good evening, sir. Thanks for joining the program.
My pleasure as always.
Hope you are well.
I am very, very well, sir.
I remember when we spoke on radio last week, you said the right forum for all the election disputes should be the courts, and so you didn't understand why there was all the shenanigans at the collation centers. So in a sense, NDC and everybody now being in the same court is good for us, is it not? That now the court will determine the way forward for the outstanding constituencies, correct?
Well, to a reasonable extent, you see, because I always oppose civility and rule of law. So when there is even a very banal dispute, a dispute of no consequence, we resolve it in the court rather than running after each other with clubs, guys, and whatever. But the whole point of the matter is that I do not know the full motivation for anybody to go for a Mandamus, as my brother is trying to talk about, because it lies within the power of EC to look at the results again. If it should come to the notice of EC in trying to discharge its constitutional duty that indeed and in fact somebody has been a beneficiary of electoral violence or fraud, and it is found that instead of several polling stations being put together, some were left out, and the process has not culminated in the gazetting of whoever is alleged to have won. I submit with the greatest respect that the EC, being a constitutional body and a decision maker, can remedy it without any court order. That's my humble view. I keep telling people that if somebody said, I've had a very serious banter with some lawyers, if somebody said that I want to be a beneficiary of electoral fraud, you understand, and go and sit in the parliament, that it is not the total of the pink sheets of all the police stations giving me this victory. And what kind of situation do we have in Ghana? And why should anybody say that, the EC has called us that let's come and look at it again because it is some anomaly or even arithmetical error? And the so-called beneficiary says, no, the EC can't look at it again because somebody has declared me as a winner. What if the declaration was founded on an error? That they didn't have the full complement of the pink sheets coming from the polling station. So for me, I'm of the humble view that even if you want to go to parliament, it should go beyond controversy. We shouldn't be the one who is profiting from a fraud of an election. I will say that all the time. Well, what will be your moral justification in sitting in that hallowed chamber? I mean, when you didn't win, but for whatever consideration, some people are talking about duress, some people are talking about errors in the computation. Nevertheless, I want to take the seat in the parliament. So this is where I'm coming from. You owe it to.
So for you, the EC oughtn't have even waited for a mandamus from the interested parties. But to the extent that there was a disagreement as to whether what it did or purportedly did prior to the need for recollation was valid, maybe they need a court order to be secure, because some people, of course, one party felt that you've declared and we've won. Another party says what was done was not a proper declaration. So to that extent, they would have to, they needed some impetus. Because there are two groups who believe that what you did was right and what you did was wrong. So it's not as straightforward as that.
Listen, it's all gangsterism. So there's this usurpation of the mandate of a constitutional body. You understand? So who are you to determine that what has been declared is the finality of the matter, as far as you are concerned? You understand? Even if there is clear issues of errors, should the errors inure to your benefit? You who is claiming ab initio that you want to fight corruption? How can you be a beneficiary of electoral corruption of this nature? So I don't get the point about this. The way we meet and we say, Atta, I've won as the MP for Abu Akwasa. Do you understand? I should win with arithmetic, not with choboism and gangsterism that people will go and converge at the collation center. No, go this way or go that way. If you've won, go and they look at it again. Oh, the person is won. That is the end of the matter.
Okay, fair enough. Now moving forward, the mandamus was moved and the court agreed, albeit the other party, being the NDC, had wanted to file a joinder, and the High Court judge did not think it was necessary. So the NDC went to court, Supreme Court, for a certiorari, which succeeded largely in part. What do you make of that, though? The fact that yes, they've gone to court with a mandamus, and yet an interested party was not allowed to join. Of course, the Supreme Court felt that was wrong.
I want to tell you now, I'll say it anyway, the judges are prone to error.
Okay.
Unless you can prove palpable mischief. Somebody was arguing that when you join, you become a relevant party to the action. Relevant. And somebody was arguing that, what is the relevance of you coming to join? You join to block a mandamus application to say that no, EC should not do his constitutional work. That will be a mischief of the highest order. But be that is as it may, the Supreme Court has said that look, they have an ultimate advantage one way or the other, so bring them in. They should go in and whatever they want to canvass for the joinder, they should canvass it. And as to whether or not it is somebody who is going to say that look, by reason of the joinder, I am of the humble view that the mandamus is redundant and you can't come out and issue another mandamus. They should go and canvass their position. That's the beauty of the law. Go and canvass your position before the judge. But the Supreme Court has spoken, and let's go by what the Supreme Court has said, and then let's see how in the final analysis anybody can seriously say that I wouldn't want EC to do its work, even if there's a palpable, egregious error.
I see.
In terms of the computation, and somebody is very, very, very happy to be the beneficiary of electoral corruption of this nature. We will see.
Final point before I go for my first break. A lot of what you said in the first part of my question and this one would be true, especially if all sides think that the referee is objective. I think in the first point, one side thinks the EC is not being fair to them, and even to an extent in the second point as well, the NDC felt like the High Court judge was not being fair, was biased against them. So it seems as if, yes, the court will have to decide, but there has to be a certain perception of objectivity and fairness, which is unfortunately the EC from one side is not perceived to be so. So it makes this quite complicated, doesn't it?
It doesn't make it any complicated. You understand? That sense of fairness, you should show that the EC is embarking on a journey to subvert, the constitutional process. You see, but if you are dissatisfied with coming to, validate elections that you claim you've won, and you have developed an allergy to that process, you talk about EC being biased. How can you say I've won elections, and somebody saying that, look, I don't think so, by reason of a deficit of the collation in about maybe 10 polling stations. But you, the so-called beneficiary of the election, won't come and say that, oh, are you sure? This is nonsense. By my polling, my pinches from the polling station, I've won convincingly. Why would anybody run away from collation? I can't get it. If you've won convincingly, like the president-elect won convincingly, you understand? You shouldn't shudder at all in conversing with anybody. Now look, this is the arithmetic of my victory. And that's the end of the matter. You damn anybody who was trying to challenge that you didn't win. Guess what? The whole process of the collation culminates in the gazetting. So if somebody said, oh, they announced something, and because they announced something, that's the end of the matter. They don't have a good sense of the work of the EC.
Fair enough.
But whatever regulation you want to talk about, because nobody can profit from his own wrong. That's the very primal principle of law. You can't profit from your own wrong. So nobody should be a beneficiary of electoral theft. And if I'm not a thief, morally, I should go and meet the EC, together with representatives from whatever, and show the EC that, look, probably my arithmetic is challenged, and on the full welter of my preaching makes me a winner. That is civility, not gangsterism. And people believe that, look, I won't go again, I believe I've won. I don't believe in looking at the entirety of the thinking.
All right,
that is very important.
Fair enough. I'll come back to you later to look at how seminal tomorrow's judgment will be, but let me come back in studio and speak to Edudzi. Any reaction to Atta's comments?
Yes, my learned senior, I greet him. I think that he's missing a few things. I recall in 2020 when Techiman South happened, the then minority leader Haruna Idrisu led a group of minority MPs to the Electoral Commission with a petition, if you recall. And we said, look, it's a numbers game. So if you are so clear that the numbers favors you, permit a recollation of the results. The Electoral Commission issued a response to us, and in paragraph 13 of that response indicated that recollation can happen at every stage, but before declaration, and that when there is a declaration, the avenue for you is the judicial process. I agree with my learned senior when he makes the point that nobody should benefit from the wrong done. That's trite. But you see, there are processes allowed in our laws. And one of the processes is to come with a petition. And I'll tell you something. When we went to the the High Court, and we had filed the application for judicial review, guess what? The Electoral Commission came to court without any affidavit in opposition. Now, if you are saying that your officers were under duress, and that it is the basis of duress that they made those declarations, permit all those officers to file respective affidavit in opposition detailing out the nature of duress. Look, Bernard, your station covered the declarations. Many other stations covered it. So when you come out and you say that a particular returning officer did a declaration because gun was pointed at his head, there should be video evidence of that. People will see it. I'll give you a classic example. Obuasi East. The returning officer Frederick Mensah, who declared our candidate in Obuasi as the winner, the person who signed the declaration form on behalf of the MPP candidate, the sitting MP, was himself. Was himself.
This is Obuasi East.
Obuasi East. Our candidate signed the form, the declaration form, for himself. Now the same returning officer, in the face of police men and everything, now he comes to Akyea and says, I did that under duress.
Maybe there was something happening outside the building that put pressure on him.
With the greatest
there were some places where there were supporters outside. So maybe he feared for his life after declaring in a certain direction.
No, you see, the MPP candidate signed for himself. So he too, he was afraid. It's not possible.
But that's just Obuasi East.
Obuasi East. Many of the other places, there are video evidence of how the declaration happened. My point is that the fact of declaration is not enough, because there's a judicial intervention to correct that wrong. And so the EC in 2020 told us that we should go to court. So what did we do? We went to the High Court in Wenchi, and for 3 years litigated the matter. Eventually the High Court said the declaration was proper. I tell you this. In fact, the last case Nana Addo Dankwa Akufo-Addo did as a private legal practitioner before he stopped was this case of Republic versus High Court Bolgatanga, ex-party Hawa Yakubu. What happened? Hawa had been declared and he was in parliament. Unknown to her, the NDC candidate had gone to the Bolga High Court without Hawa. And the High Court made series of orders, including an injunctive order against her. That is what made Nana Addo Dankwa Akufo-Addo to file the judicial review application in the nature of Seshurara and others to quash the judgment of the High Court, the orders of the High Court from Bolga. And what was his argument? The argument Nana Addo Dankwa Akufo-Addo put forward was simple. That to the extent that there is a declaration in favor of Madam Hawa, any judicial proceedings, she ought to have been or brought to her notice or made a party, so that at least she can defend herself. You know why? Because you see, growing up, Bernard, when we want to kill fowl around this Christmas, often we'll give them water to drink. And it's from the biblical position where, even with the idea that God is all-knowing, God is ever-present, when Adam ate the fruit, God didn't leave it there that I knew what you have done and I knew who corrupted you. He said, Adam, what have you done? At least he offered Adam the opportunity to explain himself. And that is all that we asked for. It is not an issue of trying to protect a particular outcome, but just offer us the opportunity and to correct. So it's not the simple issue of giving benefit to gangsterism.
I get it.
Or whatever.
I just want to clarify something when we come back. It looks like for both applications in the High Court, the EC, for the MPP application, the EC had no objection. But for your application as well, which was the second matter, they did not file something in opposition as well.
Yes.
So it's almost like the EC was just taking a laissez-faire position?
No. So you see, so this is what happened in the case of mine. When I began to move, I said, my Lord, let it be on record that the Electoral Commission, through their lawyers, have not filed any affidavit in opposition. And the rule of law is that where an application is served on you and you dispute the facts, you file an affidavit in opposition denying those facts. In this case, in the absence of any affidavit in opposition, the claim that we have made in our affidavit in support should be admitted or deemed admitted. The judge says no. Then we say, but my Lord, you are like
the same court, same judge,
the same second, exactly the second one. And so we say, my Lord, with the greatest respect, you are the neutral person interfacing us. At this point, on what facts or counterfacts are you going to give out a contrary decision? None.
But you can't have the first decision and second decision happen at the same time, though, because the first matter NPP took for for the Mandamus, if that is granted, that obviously vitiates yours.
Exactly.
So it's essentially the same case.
So right from the beginning, I drew his attention that, my Lord, even we filed first in time, which was on the 16th. So give, hear us first. And if you hear us first, it will put matters in proper perspective.
Because you had said that the declarations that were done
were valid,
and so the so-called recollection should stop.
Exactly.
MPP's number 2 to 6 says, EC...
There was even none.
No, MPP's point is that EC should be compelled to collate and declare.
Exactly.
Because they believe that a proper declaration was not made.
Exactly. So
I get that point. Let me take a breather.
Okay.
A lot of legal